Hey, can you hear me? Can you hear me? Yesterday, prosecution opening statement was great. It was nice and succinct and made a lot of sense. And it gave like a really good overview of the case. Defense got up there and it was alleged this and supposed that, and that guy talks so slow. Oh, let me grab my notes. The first witness was Doug Benefield's first cousin, and he talked about the first time that he met Ashley and that how in love they were and that everything was fine between them. And then he got to some texts. The defense got to some texts. Oh, hey, Christian. The defense got to some texts that he had exchanged with Ashley, and he kept trying to get him to say that he had texted her that she married the wrong Benefield, because his last name is Benefield too, because they're first cousins. And that opened up a can of worms, and they were all up at sidebar, and then they go back and he'd try to ask him the same question again, and they'd be up at sidebar. And that was the very first witness. And finally the judge said, you can ask him if he felt that way, but you can't ask him if he said that, because he never said that in the text. So finally, I don't even think he ended up asking that. I think finally he just gave up. But he said it would discredit him as a witness. I don't know how that discredits him as a witness, that he kind of had a crush on her too. He said, but Judge, there's 5 women on the jury. That's going to discredit him as a witness because he supported her and liked her and said that she married the wrong Benefield. And I'm thinking, how is that going to discredit his testimony that they were in love? All it does is say that he liked her too. How does that discredit his testimony? Which that whole witness, that was just kind of strange. And then the second witness was his daughter, which basically all she said was that she never saw them fight. Not even like a verbal argument. She said that if Ashley wanted something, she would just like harp on it and just talk about it all the time, just talk and talk and talk, and that all her dad would do would just sit there and listen, just like let her keep going on and on about whatever it was that she was wanting, and wouldn't argue back or anything. Like he would just sit there and listen to her. Now there was talk about a whole, I know, right, Christian? That's yeah. Yeah, he doesn't. Why is that not work? Yeah, he doesn't seem to know when he's lost an argument. Exactly. So the daughter did was asked about a hole in the kitchen. Apparently, Ashley claims that he shot a gun in the kitchen when they were having an argument to make, I guess, to make her quit arguing. And the daughter did not see the argument or see it happen, but she did see the hole in the kitchen. And then there's another hole in the drywall where I guess he punched a hole in the wall, which to me, that doesn't bother me. I'd much rather, if somebody's mad at me, I'd much rather them punch a wall than punch me. But that's me. That's just me personally. I know a lot of people don't like it when people punch inanimate objects instead of punching somebody. I mean, or, punching anything is violence to some people. So, but that was a thing my brother used to do. One time he and my mom got in an argument and he punched the wall. And then he ran out the back door. He was so mad. And then he came back and he goes, "Mom, I think I broke my hand. Take me to the ER." And she was like, "No, I hope you broke it good." So I guess maybe that's why hitting the wall when you're mad doesn't bother me, because that's what my brother did when we were growing up. So and then they did not excuse his daughter from her subpoena and told her she couldn't stay in the courtroom and she couldn't watch the trial on TV at home, yet she stayed in the courtroom. And nobody said anything to her. So I don't know if that's going to screw up anything or not. I don't know if the defense is planning on calling her later or what, but she wasn't supposed to stay and she stayed. Yeah, the only time I've ever wanted to hit somebody was I was in a long distance relationship once, and I was actually engaged to this guy, and he was in the Navy, and when he was deployed, he cheated on me. It's the only time I've ever tried to hit anybody, and he blocked me, and I didn't get contact, which is probably a good thing. Why is there no sound? I guess they're off the record. No, she's the court reporter doing her thing, so that's Eva. She's in the courtroom again. She's not supposed to be there. And then the rest was like just deputies and CST. So that stuff was just like your normal trial stuff. There was one thing that I wanted to ask Alita about, but I think I figured it out. One of the CSTs took photos of her. She did have some scratches. They don't look like she was abused. I don't know how she got the scratches, but they're just like they're just like a teeny tiny scratch. They don't look like she's been in a fight or anything. There was one like on her bra line. Am I still in frame? I feel like I'm drifting. There was like one little scratch on her bra line and then one little scratch on her hip. Well, yeah. I'm muted. How long have I been muted? Oh, good Lord. Why is there no sound? Oh, there we go. Okay, with me. I know. I was muted. I'm an official YouTuber now. I was muted and talking.
All right, y'all can have a seat. Good morning, everybody. Welcome back. Check and make sure we got the right notes in the right place. Those are yours. Check your pens. Make sure they still got plenty of ink. All right. Good morning, everyone. Just want to make sure that nobody began discussing the case amongst yourselves or started deliberations. Nobody discussed the case last night or this morning with anybody outside of the jury. Nobody approached you or talked with you or tried to influence you in any way, and you didn't do any research on the people, places, things, or legal topics we've heard anything about.
Official.
All right, everybody says no. Thank you. When we finished up yesterday, the state was still presenting its case. So, state.
State calls Alicia Byers.
Oh, that's her mom. I have a pin somewhere. I'm prepared this one.
You saw his swear affirming testimony you're about to give be the truth, the whole truth, and nothing but the truth.
Here it is.
Good morning, ma'am. My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. We need to get you about 12 to 15 inches from that microphone. It does adjust up, down, left, right as you need it. If you speak in a loud, clear voice right into it, it'll
All right, let's get rid of that.
Thank you.
Come on.
Yes, ma'am.
Good morning. Please state your name.
Alicia Byers,
Can you spell your first name and last name, please?
ALICIA BYERS.
And your relationship to Ashley Benefield.
Is my daughter.
And when did she start living with you in Florida?
I can't clearly remember.
Okay. Was the time Ashley moved in with you when she was pregnant?
Yes,
Okay. And she was married at the time, but it was just Ashley that moved in?
yeah, he brought her down.
Okay.
And yes, and yeah,
And she moved in with you?
yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she stayed with you from that time on, correct?
Yes,
Okay. And does Ashley have a concealed weapons permit?
yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms then?
Yes.
Okay. How many?
2, I think. Yeah, 2.
Did she ever go to the firing range or anything?
Yes,
I'm sorry.
yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Fantz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Fantz?
I'm not sure.
Okay.
I don't know.
Okay. And you and your daughter obviously are very close. You lived together, just the two of you, right, for a while.
Mhm.
And then once the baby was born, the baby lived there with you,
Correct.
correct? Okay. And Around that time of the shooting, were you planning to move to Maryland?
Yes,
And you had a house that you inherited in Maryland?
it was the house I grew up in.
Okay. And you inherited that house?
Yes,
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mhm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
he was moving somewhere else. He was, yeah,
Okay.
he
So
had found his dream job.
So he was moving to Maryland, but not moving into your same house.
Correct.
Okay. And he was moving, packing up to move at the same time you were.
I assume so, yeah.
But he was coming over to help
Yes.
you move.
Yes.
And on a regular basis, almost every day, he was at your house.
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that.
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway, though, correct?
No, it was not my driveway.
The day the shooting happened, was it in your driveway?
It, I think it,
If you don't know, that's
U-Haul
okay.
was getting there when I was leaving.
Okay.
Yeah.
You also had a pod
That was in my driveway.
in your driveway. Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light out.
Oh, yeah.
And maybe in the afternoon sometime.
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. And when you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson. And
Yeah.
how old was she at the time?
So I guess 2, maybe. Yeah.
Approximately.
Yeah.
And at the house, was it just Doug and Ashley then
Yes.
when you left?
Mhm.
And you,
Yeah, I was going to say she has direct examnesia instead of cross examnesia.
obviously been in contact with your daughter almost every day since the shooting, correct?
Leading. No,
You've been in contact with her basically every day, correct?
Not initially, no.
For the last several years, you've been in contact with her every day.
Well, yeah.
Okay.
I
And
don't know how to, okay, yeah.
did she ever, during any of these conversations, tell you what happened when she had to shoot Doug?
Never. Nope.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
I had no idea where she was.
also staying.
Okay.
I don't buy that. I would tell my
So
mom
at
exactly
the
what happened.
time that the shooting happened, she didn't tell you what happened?
No,
Correct.
we've never talked about it.
And
No, overruled.
to this day, you've never talked about it?
No.
Thank you. No further questions.
Cross.
Good morning, Ms. Byers.
Being good about being get in,
Are you
get
nervous?
out.
Yes, very.
It's not like Lally with
Scared?
all the
Yeah.
millions of
Just try to
unnecessary
relax.
questions.
If my questions aren't clear, please just ask me to repeat it.
Okay.
Yeah, this is for mom.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
Would it be safe to assume, and perhaps you lighten us a little, how was your relationship with your granddaughter, Emerson?
Oh.
Time with her?
Yes.
Would that include you taking her somewhere would it be safe to assume, and perhaps
Okay.
you can enlighten us
Are
a
we
little
good
bit,
now?
how was your relationship with your granddaughter, Emerson?
Are we back?
Oh, very good. Yes,
Okay.
we're very close.
And would you try to spend time with her?
Yes,
Would that include you taking her somewhere on a regular type basis?
yeah,
Would that be to the park?
yes.
And tell the ladies and gentlemen of the jury,
Okay, good.
Ms. Byers, how often you engaged in that practice of you and Emerson going to the park?
Usually several times a week. And we'd go after it cooled down because the park is not a very good, tree coverage. So it was very hot. That was the only comfortable time to go.
So we think trying to avoid the heat or
Oh, yeah.
minimize it, it'd be later in the afternoon,
Yeah, it was brutal out there otherwise.
Yeah.
Florida,
almost as bad as it is now.
Right, exactly.
Um, how far away was the park?
It's a short walk. I mean, we'd always walk over there. So I
Mhm.
don't know, take us maybe 5 minutes to get there.
Okay.
So
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived.
yes, we're walking down the driveway and I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like
no.
you
No,
did
that's
regularly.
Yes.
Give me a moment, Your Honor, please.
That never seemed suspicious to me until just now.
I believe that's all I have, Your Honor. Thank you, Ms. Bell.
Can you redirect?
No.
Oh, hold on, ma'am, don't get up yet. No redirect.
No.
Can this witness be released?
Yes.
Yes.
Ma'am, you are released from your subpoena. Your, the rule of sequestration had been invoked, but you're now released from your obligation.
Okay. All right. Thank
There
you.
you go. Thank you.
Judge, I apologize. In consulting with counsel, I do think I want to leave her under subpoena
All right,
for, sorry.
Ms. Byers.
So what does that mean?
I'm going to explain that.
Okay.
All right, so what that means is you remain under subpoena and subject to being recalled at the trial.
Okay.
The attorneys at the beginning of the case invoke what we call the rule of sequestration.
Or
So the instructions I'm going to give
she
you
didn't
are
have to
similar
know
what's already
anything,
probably
but
been told by the
Ashley could have
attorneys.
been.
You're not to discuss your testimony here. in
Okay, this
court,
is
the questions
speculation.
asked of you with anyone else,
Ashley
including
could
the
have been like,
attorneys,
Mom,
you
take
can't
her to
talk
the
with other
park
witnesses about
while
what
we
their
pack,
testimony
'cause
was or the questions
just to
they
keep
were
her
asked.
occupied and out of our
And,
hair.
It's my
And, like,
understanding this may be
Ashley
online.
might have been
You're
planning
prohibited from watching anything that's
something,
going on within these four walls, ma'am.
but she
Until
didn't
you're
tell her
released
mom
from your
anything.
subpoena
You know what I
or
mean?
Until the jury comes back with a verdict.
But I'm not saying that's what happened. I'm just saying that could have been
You're
what
free to go for
happened.
now. All right, State.
State will call Barbara Russell.
Oh, this way. There you go.
I don't know if this is. She lived with her therapist, like roommates, for a while. I don't know if this is that one or not, because that was part of one of the pretrial hearings was about her therapist testifying. I don't remember if this is the one or not, but I guess we'll find out in a minute.
Good morning, ma'am.
Good morning.
My name is Judge White. I'm going to be presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right, however you need it. But if you just speak directly and allow clear voice into the microphone, it'll pick up everything.
Thank you, sir.
And please state your name.
Barbara J. Russell.
Can you spell Barbara Ann Russell?
BarbaraRussell.
And what is your profession?
I'm a licensed clinical social worker. I have a doctorate in clinical psychology, and I work as a clinical and forensic mental health professional.
And how long have you known Ashley Benefield?
I've known her since April of 2020.
And when you first became involved with Ashley, it was on a professional level, correct?
Correct.
All right. And then since the time that you had that interaction, you have stayed in touch with Ashley.
Correct.
And subsequent to the shooting that happened, she actually moved into your house, correct?
Correct.
And who all lived at the house?
Myself, my husband, and my 19-year-old daughter.
And approximately how long did she live at your house?
Approximately 8 months.
And you would see her on a daily basis?
Pretty much, yes.
Okay. Did she, when you first spoke, when did you first see her or speak to her after the shooting?
About 1 o'clock the following morning.
Okay, so this happened in the evening time, so it would have been 1 o'clock the next morning. And at that time, did she say to you, "Oh my God, he came after me, I had to shoot him"? Did she say that?
She didn't discuss what had happened at all, nor did I ask.
Okay. And to this day, are you still in contact with her?
Not that one. I'll overrule on that question.
To this day, are you still in contact with her?
Yes.
And to this day, has she ever told you what prompted her shooting, Doug Benefield?
She never gave any kind of narrative of what prompted the shooting. My understanding is that
I
she was
just want to know if
defending
she
her life.
told you. I just want to know what she told you. She did not tell you anything, correct?
She never gave me any narrative about what had happened.
Thank you. No further questions.
Cross, sir.
Can't tell what you don't know. She's not stupid.
Good morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
Give me just a moment, Your Honor.
Of course. Yes, sir.
Did there come a time, Dr. Russell, when a detective, Warren, contacted you about the case?
Yes.
Did you have discussions with Detective Warren?
I met with him once, yes, for about 90 minutes.
She's mad because she did not want to testify. She had an attitude in the pretrial hearing because she was mad because there's no like HIPAA waiver. Ashley didn't want her to testify, and I asked Alita about this, but she never really got back to me. She just said that she would take a look at the hearing because they lived together. There's like, I mean, they were like roommates, so there's a fine line there. What is covered under HIPAA and what's not? Like, and this was the example I used when I asked Alita. I'm like, what if they're just like sitting down on the couch watching a movie, eating popcorn, and she happens to mention something about, Doug did this or Doug did that? I mean, does that fall under HIPAA? No, it shouldn't. They're just like sitting on the couch watching a movie. They're roommates. At that point, is she still her therapist, So, and then Alita never got back to me on that. But that's what's off about her. She's mad and doesn't want to be there.
And in that meeting, did you relate to him that,
Objection.
I'm asking a question to this witness.
Well, I understand, but if it calls for hearsay, once you approach, so I can hear what the question is going to be.
Ooh, I can zoom through this one. Yay.
When you spoke
Zeal.
to
Yeah.
Detective Warren, Justin, you identified yourself.
Correct.
This was a face-to-face conversation.
Yes.
if you were to tell us today in court about the discussion you had with Detective Justin, would it be any different than what you told Detective Justin on that day?
No, of course not.
You have an opinion, do you not?
Objection.
Rephrase.
I don't blame
As
you.
you sit here today, do
Wow.
you have a conclusion?
Objection.
Sustained.
All right, give me a moment.
That's crazy.
Can I see the pictures that were entered yesterday?
Not all of them. Sometimes you have to shop around. Seriously. I've had several, and there's some that are great, and then there are other ones that are horrible. I had one tell me that all I needed to do was, this was years ago, but that all I needed to do to be happy was to lose weight and get married.
You had an
That would cure my
opportunity
depression.
that morning, from what you had to say, at approximately 1 o'clock, technically the next day, to observe Miss Benefield, correct?
Yes.
I'm going to pass you a picture that's previously been marked as State's Exhibit number 21. Picture of Ashley Benefield that was taken on the day of the incident.
Yes.
May I approach you on it?
Yes.
Does that picture reflect any swelling to Ashley Benefield?
Objection, as interpreting the picture.
Sustained.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay. What was different about her?
When I saw her after the incident, there was edema, swelling on the side of her face.
Okay, and did that include her right eye,
It included her left eye.
left eye rather?
Yes.
Okay. And when you saw her before the homicide, did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
In fact, when you saw her immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection, hearsay.
Sustained.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we approach?
Yes.
So I remembered what I was talking about when I was muted. There was something that I didn't understand yesterday. I was going to ask Alita, but I think I figured it out. So somehow she had an attorney waiting for her at the jail. So when they took pictures of her, the attorney, it wasn't this attorney, it was a different attorney, they took a picture of her left ear because the attorney said that her left ear was red. And there was an objection, hearsay, and the attorney said it's for effect on the listener.
Did Ms. Benefield that morning give you any indication that she was in pain?
Yes.
And did you refer to any particular area?
So I think that means effect on the listener. I think that is when, so if somebody says something and it's hearsay, but it can be mentioned in court, because effect on the listener, it's like, what did you do next because of something someone said? Does that make sense? So like, she had redness on her right forearm where they're saying that he grabbed her. So they swabbed her arms for touch DNA, and they took a picture of her left ear because the attorney said it was red. She had a scratch on her bra line, a scratch on her hip, and they swabbed her hands, wrist, forearms. But they didn't, no CST has said what the results were, if the swabs came back with his DNA from the touch DNA on hers. So she wasn't like, they collected her clothing. We haven't got any of the results from the testing yet, just the CSTs that said what pictures they took. And so that's okay. So that's my leftover from yesterday. I'm sorry. Here we go. I'll start it back up.
Yes.
What?
Her head.
Thank you.
Redirect.
No.
Can this witness be released?
Yes. I'm sorry. No. She is to remain under subpoena. She can be released at this time.
Ma'am, the rule of sequestration has been invoked by the attorneys, so that
I
means
have
that
never seen so
until
many
you're released from your
witnesses not
subpoena
be
or
released
until
from their
the attorney is
subpoena.
discharged, you're not to discuss
That's
your testimony
crazy.
in this case with anyone outside this courtroom, including the attorneys. You're not to talk with any other witnesses about your testimony. You're not to talk with any other witnesses about their testimony or the questions that were asked of them. And it's my understanding this may be online. You're prohibited from watching anything that's going on within this courthouse.
Absolutely.
Thank you, ma'am.
Thank
Just
you.
leave the picture there.
I will do so. Thank you.
All right, state.
Judge of the state called Lieutenant Dan Dickerman. I know he was caught in the line, so I just wanted to make sure he's here.
I don't know what value she added to anything.
We have an issue here I'd like to take up for just a
Oh Lord, an issue. He makes issues out of nothing.
Hold on one second. I'm approaching.
I don't know if it's a capital case. I actually don't know. I don't know. I don't even know if she's charged with first degree or second degree. That probably should have been something I looked up before I started this, huh? This was kind of a spur of the moment thing because I have spent the last, well, not yesterday, but like all weekend and Monday going back and forth in my head. Am I going to do this? Am I not going to do this? Am I going to do this? Because I wanted a place, because as soon as I found out Alita wasn't going to do it, I wanted a place where we could all watch it together as Bike Club. And nobody showed up. All the people that was like, do it, Debbie, do it. None of them have showed up. Just my twin and my Christian and my mountain princess. All the important people are here.
Hello, sir.
Yes, sir.
My name is
Oh,
Greg Ryder,
thank
presiding
you,
over the case. As the
twin.
deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. If it does adjust up, down, left, right, however you need it. Just speak in a loud, clear voice, we should hear it.
Yes, sir.
Good morning.
Good morning.
Please state your name and
Lobster
spell your
voice. Do you see that?
Daniel Dickerman, Dickerman.
last. Where do you work?
With Manatee County Sheriff's Office
Did
How
you
long
see
have
the
you worked
closed
there?
captions?
for
Lobster
almost
voice.
29 years.
What is your current
Oh, I
position?
love you too.
I'm a lieutenant in road patrol.
And what was your position back in 2020?
I was the senior homicide investigator assigned to the Manatee Homicide Investigative Unit.
Okay, so Manatee County, say that again?
Manatee Homicide Investigative Unit, MHIU.
MHIU. Okay,
Yes.
so you were the senior investigator in that unit.
Yes.
And if you could just explain a little bit, what is that unit?
So that unit is a group of detectives formulated from
Aw, that's
all the
so
agencies
sweet.
within the county, the Sheriff's Office, Braden Police Department, Palmetto Police Department, and all 3 beach agencies.
Just because of there.
We all respond out to all homicides that occur within the county, regardless of city jurisdiction, everything, so we can all work together and investigate that and determine if any criminality as a result of that homicide will need to come forward.
And just discuss a little bit how you work as a unit, and is that different than how a detective may work in a different part of the sheriff's office?
Yes. In the sheriff's office, most cases are assigned to a single detective. They go out, they do all the work, they write the report, they bring everything together in a normal, smaller case. In these cases, we determine what we call a lead detective. That lead detective then becomes, for all intents and purposes, the supervisor of the case. He makes assignments. We go out, all the other detectives, we do our respective assignments, we report back. The lead detective becomes a basic gathering point and a keeper of all the information to make sure the flow goes smoothly to one location and we're not duplicating efforts or stepping over each other's toes. And then he makes the ultimate decision once he has all the information.
Okay. And are you, as a unit, a part of any decision-making that happens within the unit or that happens in a case?
Yeah, we have meetings on every case
Okay.
to discuss the comings and goings and the happenings of the different case.
And so did you work in this unit, the MHIU, at the time that the shooting occurred?
I did.
On the date of the shooting, were you called, were you notified of the shooting?
I was.
Okay. And about what time was that
It
approximately?
was between 7:30 and 8 p.m.
Did you go to the scene?
I did.
And when I say the scene, where the shooting happened.
Yes, to the neighborhood of
Okay.
White Rock, I believe it was.
Was the defendant there?
Yes.
Where was she?
She was in the back seat of Deputy Burley's patrol vehicle.
Did you go into the house?
Not at that point. I did after the crime scene unit had already documented everything and made sure nothing would be contaminated, done their investigation inside. Then I went in briefly at the end.
Okay. And what did you see?
I saw some blood trail on the floor, a bullet strike in the wall of the bedroom from a projectile. And that's about it.
And were other members of your unit there at that scene?
Yes.
Were there other members of the unit at other scenes or other places?
Yes. Detectives were also sent to our main offices, Criminal Investigation Division, which is where our interview rooms and our offices are located.
Okay. And from the beginning of when you arrived on scene, you knew that there was a self-defense element of this crime. Did you know there was a self-defense element when you got there?
I will rule on that.
Yes.
While you were at the scene, were you made aware that the defendant was going to be going to the station?
Yes.
Okay. Was the defendant's mother, Alicia Byers, there?
Yes.
Did you speak to her?
Yes.
And at some point, did she hand you a phone?
She did.
Okay. And did you know why she was handing you the phone?
Originally, no, but then
Okay.
I found out shortly after.
Who was on the phone?
A lawyer.
And did you speak to that lawyer?
Oh, mom called the lawyer. Okay,
Did
well,
you
that
explain
tries to make
to Alicia Byers what was going on and where her daughter was going to go?
I did.
And ultimately, how many lawyers ended up at
Okay. Relevance.
If you want to approach and explain the relevance.
was she ever arrested that night?
Jack leading.
When was she arrested?
Sometime in November.
There you go.
And the shooting
Quit asking
happened.
yes or no
In
questions.
September.
It was worse yesterday.
And that seems to be a month or two delay. What do you know what delayed that?
Way worse
For the
yesterday.
investigation to continue into the self-defense claim.
Did you go to the neighbor's house, John Sant?
I did go there briefly, yes.
Okay. And did you have any discussions with him or anyone?
I did not know.
Okay. Was Child Protection Services on the scene?
Yes, they were called to the scene.
And just briefly, what is Child Protection Services?
Objection. Relevance. Consistent with the court's prior concern. 403.
Overruled.
What is Child Protection Services?
At the time, it was a division of the sheriff's office entrusted with protecting the children from abuse, or make sure they're in good locations, or just make sure they're healthy.
Okay. So why, do you know why they were there?
Objection.
Did CPS try to speak to Alicia Byers?
Yes.
Were you present when
Yes.
Alicia Byers?
Yes.
Was Alicia Byers cooperative with them?
I wouldn't say fully cooperative. She did ultimately answer a vast majority of the questions, but not cooperative per se.
Okay. And was there anyone else present at the time when they were trying to speak to Alicia Byers?
Off and on, Barbara Russell was present.
Did you also assist in executing a search warrant?
Yes, I was on scene
And where was that search warrant? Was that at the house?
at the house.
Okay. Did you have any assignments for gathering evidence?
Yes.
And what evidence was that?
To originally look for video in the area of the park of the neighborhood.
And did you do that?
I did.
Were you able to obtain video?
I was.
And on that video, did you see what we believe to be Alicia Byers and the child at the park?
Yes, they were at the park.
Did you also obtain other types of videos?
Yeah, I also viewed ring video from the scene itself.
Objection. Relevance.
What video?
Ring from the
Ring.
scene.
Overruled. I mean, you could say he viewed it.
And in viewing that, did you see any part of the incident that we're here about? Was it captured on the Ring camera?
The shooting, no, the arrival of the U-Haul and the arrival of the deputies were on there.
Okay. I have no further questions. Thank you.
Oh.
Good morning, Lieutenant.
Good morning.
So through your testimony, among other things, the state proved this morning that there was a U-Haul truck there
Yes.
and that the deputies arrived
Yes.
and that there was a homicide.
Yes.
Okay. Now, you mentioned that often the practice is when you respond to a homicide, it takes some time to conduct an investigation to determine if there's criminality.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body it's murder.
Correct.
Okay. If I wanted a job in your unit that you supervise and I felt all homicides are murders,
Objection.
fair question, Your Honor.
Objection. Travel one.
Did you see the look on her face?
You mentioned that the arrest of Miss Benefield, well, let me start from, I think you told us she was in the back of the squad car.
Yes, sir.
She was in handcuffs.
Yes.
And this is a squad car with the doors that you can't open from the inside in the back, correct?
That's correct.
With a cage.
Yes.
So she's in the back of the squad car, in handcuffs behind her back,
Yes.
in a car with a cage, and you can't open the doors, but she wasn't under arrest.
No, she wasn't charged with anything.
So I think you told us that the reason for her being arrested approximately 6 weeks later, I think, was so that the investigation could be conducted.
Correct.
Because you had to determine if there was criminality.
Correct.
Okay. Could have been a homicide that was self-defense.
Could have been. That was the claim.
That's the whole point of the investigation.
Absolutely.
And that kind of an investigation, understandably, takes time
It does.
and patience
Yes.
and professionalism
Yes.
and knowledge and experience.
Yes.
Okay, we get it. Moving on.
Do you know how old Lieutenant Alicia Byers is?
I don't.
Do you recall meeting her?
I do.
Approximately, give us your best shot.
Relevant?
I mean, I would guess in her 40s to 50s.
All right. Was she a young woman?
No.
She was pretty exhausted that day, wasn't she?
She appeared to be. There was a lot going on.
Yeah. Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the
Objection.
cars was
Hearsay.
that her daughter was
Please
dead.
stop
Sustained.
talking.
Unless you'd like to make an argument for an exception, then you can approach.
Rest gesti?
If you'd like to approach.
It's all right, Your Honor. I think, Lieutenant, excuse me, you told us that you went into the residence after crime scene had completed their portion of the investigation.
Yes, sir.
And do you recall crime scene was there before or after EMS?
A crime scene comes after EMS. The sanctity of life always comes first.
All right. So EMS was there first, and you were there, so you know they dragged Mr. Benefield out of the home from
Yes.
the bedroom.
Yes.
So when you told us that crime scene was there to preserve the scene, can we agree, Lieutenant, that what crime scene preserved was the scene following the EMS people not only working on him in that bedroom, but moving?
Yes. As always, that we preserve the scene after we attempt to save the life.
Okay. And so those crime scene photos show us, for example, what that scene looked like when crime scene took the photograph.
That is correct.
It doesn't show us what the scene looked like when EMS was running around doing what they do.
That's not possible. No, that's correct.
Okay. And that would have included the initial deputies on the scene as well.
That's
God
correct.
bless you. Give me just a moment, Your Honor. Thank you, Lieutenant. Appreciate your candor.
Thank you, sir.
That's all.
Rita Wright,
Yeah,
can this witness be released?
yes.
Mr. Taylor, can this witness be released?
Yes.
from your subpoena? Sir, you were released from your subpoena. You're free to go.
Yes, sir. Thank you very much.
On state.
Can we approach?
Oh, I thought I accidentally paused it again because I didn't hear any. Did I pause it? Can you hear me? Is everything good? My phone needs to quit ringing, is what needs to happen. Nobody ever calls me. Start the live stream and everybody wants to call me now.
All right, here's the jury. We're going to go ahead and take our mid-morning break right now. So you can step back into the jury room. Please close your notes. Leave them right where they are. It should be 10 or 15 minutes. Stretch your legs. Get something to drink back there. Use the facilities. Please don't begin discussions amongst yourselves. You are free to still use your cell phones to send and receive text messages, calls, anything like that. But please don't discuss the case outside of this group and don't do any research on the people, places, things, or legal topics we've heard anything about. Thank you.
I wanted to be a lawyer. I was going to be a lawyer if I didn't like being a nurse, but now
All right, y'all can have a seat. We'll be on
I don't
recess.
think I could handle the pressure of being and also I'm not thick-skinned enough to be a lawyer. I would probably break down in tears at least once a day if I was a lawyer. And I don't have a poker face at all. Even as a nurse, there would be days that I would go in the bathroom and cry. I'm not a thick-skinned I've gotten better as I've gotten older. I can at least stand up for myself now. But my mom was really overbearing, so I was kind of taught you don't talk back, you don't cause a confrontation, you just go with the flow and do what people tell you to do. And then in nursing school, we were taught question everything. You don't just do what someone blindly tells you to do. And so that's kind of when I started learning that I have to cover my butt, because just because somebody tells me to do it doesn't mean that it's the right thing to do. And now that I'm older and I've had run-ins with people, I'm starting to learn that I just can't let people tell me what to do. The first time this is going to sound really weird, first time I ever stood up for myself, probably about 10 years ago. My husband's ex, his daughters were at our house, and his ex and her husband and her other two kids they came over and no warning, just came over to my house. And she walks in and she tells her daughters, my stepdaughters, you need to get your daddy to take the truck and go do something, pick up something for her. Something for her. And I said, he's not your husband anymore. You can't tell him what to do. And I shocked myself. I was like, where'd that come from? And she goes, well, he doesn't have to do it right now. And like, I don't know if you guys watch the behavior panel, but you know, they call it fading facts, where like you're talking and then like you get real quiet. She did that. She was like, well, he doesn't have to do it right now. It's okay. He can do it whenever he wants to. And you can't talk to me like that. And I wish I had kept going and been like, yeah, I can, because you're in my house. But I didn't. I just let it go. I was still in shock, I think, that I even said anything to her. But yeah. Yeah, I don't have the chutzpah to be a lawyer. I mean, unless it like contract law or something like that, and that would be too boring for me. Since they're taking a break, I thought maybe they were going to discuss something with the lawyers because they just did a sidebar, but guess not. I don't think I could be a court reporter either. Why would they hate you as a defense attorney? Just because you're a defense attorney? Because people hate defense attorney. I don't know. When I started watching, well, I've been a true crime fan as long as I can remember, because I used to watch true crime with my mom. But I didn't really understand what attorneys did. You know, like all the attorney jokes. I used to make fun of attorneys and stuff. And I didn't understand what judges did either until I started watching LawTube and then talking to the attorneys and listening and knowing, you know, learning what they do. And I'm much more comfortable with defense attorneys now. Like since I started watching Lawyer, you know, I'm like, if I ever even just witness a crime, I'm going to get an attorney. Because and watching interrogation like that one, did you guys see the video that Alita did about the guy whose dad was missing and they got him to confess to murder and the dad wasn't even dead? So you need an attorney because cops can get you to say whatever they want. And another thing, see, because my dad was a cop, I've always trusted cops. I've always thought cops were on your side. They were the good guys, and that's not always true. When I wanted to be a lawyer, I wanted to be a prosecutor. I didn't want to be a defense attorney because the thing with being a defense attorney is you have to defend criminals. And I just can't see myself doing that. I mean, I know that defense attorneys are necessary because what if you didn't do anything and you're being set up? But then you have to defend actual criminals too, and that just wouldn't set that just wouldn't sit well with me. I'd lose sleep at night. I just couldn't do it. But I could prosecute people. Wouldn't have any problem with that. This is my problem with live streams. I don't know what to do during the breaks. I'm just gonna sit here and talk and feel stupid talking to myself. Well, I'm not talking to myself right now. Yesterday there were times when I was talking to myself. Yeah. Yeah, Flash fan. That's the thing. Like, I know everybody deserves a defense, but how do you defend somebody like that? I love it in Bike Club when you ask Alita questions like, how would you defend so and so? Because the thing about attorneys is that they can look at either side and come up with an argument. Like, they're trained to look at it from either side, and that blows my mind. Like, how do you do that? How do you look at somebody that's so evil yet come up with a defense for them? To me, there is no defense against being purely evil like that. A brain breaking questions. That's good. She usually has an answer though. Like, she can see both sides, and there are a lot. I really wish Alita had done this. I'm not, what's the word? Equipped. Not equipped to do this because I don't know enough about law, but because some of these questions, well, some of the defense's questions, like, I don't know why he's asking what he's asking. I guess maybe if they weren't being objected to. I never heard of that one. Science court. Okay, so I thought about being a court reporter because I'm on disability because of fibromyalgia, and now my back is screwed up. And I thought, well, if I was a court reporter, all I would be doing was sitting in a chair doing my little doot thing or talking into the thing. That grosses me out though. But I'm not sure I would be fast enough. And then you got to take your work home with you to translate it, because it's like shorthand or whatever on your little machine. And that's too much commitment. Like, I don't want to take my work home with me. That was a good thing about being a nurse. No work at home. You did everything at the hospital. But yeah, like, when the court reporter was like, stop, you can't both talk at the same time. I would be a nasty person. I would be like, y'all got to knock it off. I'd be screaming at them all the time. on, I gotta text my husband real quick.
Folks, I need the audience to sit down and take your seats, please. We need to get started.
Why did it get canceled?
All right, welcome back, members of the jury. Hopefully no one started deliberations.
It doesn't matter if it's ugly, it still tastes the same.
About the case, we're gonna need research on the people, places, things, or legal topics we've heard anything about. No?
Ugly cake is still good cake.
Call your next witness.
State called Stephanie Murphy.
Yes.
Are you kidding me? They call a witness and then they go right to sidebar. So tomorrow is my MRI. So I will be here in the morning. My MRI is at 1 o'clock. So I will be leaving around 12-ish. Don't quit. You'll find something eventually. Gotta open a door. Keep trying. I'll pray. We'll pray. It'll happen.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. I do.
Hello, ma'am.
Good morning, Judge.
My name is Judge White. I'm going to be presiding over the case. Get yourself about 12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. If you speak directly into the microphone with a loud, clear voice, we'll hear everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
Oh.
This is my 23rd year as an attorney and actually in the Sarasota Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent a letter, that she was retained to send a letter. Now going to explain something.
Okay, overruled.
What was the purpose of the letter?
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So when was the child born?
That is sad when you have to get a lawyer to draft a letter to your spouse to be allowed to be at the delivery of your child. I'm sorry. That is just that. Ugh.
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
And you said early. How many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response to that
To
letter?
my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
Okay. And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
Okay. And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And
He
you
didn't
said
even get
she
input
filed a
on the
petition
name.
For, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
So a person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent up to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has 3 options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
Cool, Flash fan. Good luck. See you later.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction. So there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And When was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay, so it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. And so he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed, and now in Florida at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision making and time sharing schedule. So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be. And of course, it can be also in a paternity case. So parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Ms. Benefield for a while. His initial...
Sustain.
Okay. So initially it was not connected with divorce.
Right. His priority was his daughter.
And you mentioned the injunction case and then your motions. Were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now, they're companion cases, though, so they might be separate cases, but they travel together as companion cases, and they're assigned to the same judge through this unified family court program.
Okay. So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Yeah, when I hear time sharing, I think about expensive condos that you pay a whole lot of money and you only get to stay in for like 1 week a year. That's what comes to mind when I hear the words time sharing.
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he, I think, had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So
Okay.
both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Yeah, she doesn't have a very good poker face.
there were also people from the Child Protective Team testifying. And so there were too many hours. And so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There
I'm
were
sorry.
other decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And I what I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did, September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
For the prior motion,
Yes.
overruled.
Go ahead.
Thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then denied the petition.
We don't want to talk about
Oh.
what went into that. We just want to know what her
Gotcha.
ruling was.
Okay, she denied the injunction. So
Okay.
that was the first part.
Okay. And then the second part.
The second part was on the parenting plan case, or the time sharing case. And so in that, she entered a ruling for a time sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise shared decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise shared parent responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay,
So when I arrived, I got into Doug's truck and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
I'll sustain as to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, well, of course not, no. And then I hung back, and Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, "I want to go with you." And he said, "Okay."
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Can we approach?
Sustained.
Yeah, I just looked up Allison Sweeney. She does. She looks like her a little bit. I've never seen her in anything that I know of.
So when they told you they were going together, what was your response?
I pulled Doug aside and I cautioned him about going with her. I advised, I'm his attorney, and so I did advise him. I said, "This isn't a good idea. She's trying to set you up for something. Don't do this." And he said, "I understand. I'm going to go ahead and do it anyway." And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby.
Okay.
For their baby.
So after this first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. Actually, before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in the court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
Overruled.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together, and so they were kind of the.
Why does he keep objecting?
And hearsay.
Overruled.
So other than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
Okay. And you said this peace lasted about 11 months. What broke this peace to your knowledge?
Well, it was my understanding from Doug that they were getting ready to move in.
Hearsay.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear the question.
During this time, did Ashley stop speaking to Doug?
Objection. I'll let you know it calls for hearsay.
Effect on the listener.
Overruled.
Thank you. They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was yes or no. Objection, non-responsive.
Sustained.
So around this time, you said November 16th?
August 16th,
August 16th.
of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all these things in.
And we're not going to talk about the specifics of that.
Sir, counsel, I'm sorry to be wrong.
No, you're not.
This is the instruction from the court about
Can we not do speaking objections?
Do you need to approach?
This trial's going to make me snarky. I don't like this defense attorney. I think we're behind. Let me see if I can zoom.
It'll take us a few minutes, so I'm going to excuse you back to the jury room. Again, please don't begin the deliberations amongst yourselves. Please don't contact or speak with anyone outside of the jury about this case. Don't do any research on the people, places, things, or legal topics we've heard anything about, but certainly you can use your phones and everything else to communicate. Thank you. All right, the jury's out. You can all have a seat. Ms. Murphy, at this point, I'm going to excuse you from the courtroom so we can have our hearing. Ma'am, the rule of sequestration has been invoked. You're not to discuss your testimony or the questions that have been asked with anyone, including the attorneys, any other witnesses, any third parties. You're not to talked with other witnesses about questions they were asked or testimony they provided, and it's my understanding this may be on the internet somehow, so you're not supposed to watch anything at all that's happening within these four walls.
Okay, thank you.
Thank you. All right, the witness is out of the courtroom. Do you have,
Judge, I don't have a specific instruction we may grab one, but what I'm looking for, so the court knows, is instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of the testimony, the other statements she will undoubtedly try to get out, are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe to provide the context of the narrative in response to the question.
so as I said, go ahead, do you want to be heard?
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity with the jury not present to look and see if there is a standard jury instruction.
I don't think
I can give it. I like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay. But obviously, none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following, and the parties ratified it. So I gave it specific to the decedent's statements in that case to, it was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. That is, the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers or listeners' actions, reactions, and responses.
I was right. Look at me, I'm learning stuff.
Except for that you are about to hear me, because they've already heard some, so.
So the court want to substitute, you've already heard and may continue to hear.
Oh, let's nitpick over
I'm
some
suggesting that I'm not suggesting that I agree to the further admission of hearsay or her interpretation that's not directly responsive to the question.
So reserving on other objections. And certainly there may be objections you have as we go where you think that they are not being offered for the effect on the listener and that it's hearsay without exception. So those still may come up. All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have heard and may continue to hear statements made by Doug Benefield, to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is, the effect those statements had on Ms. Murphy.
If I may, Your Honor.
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony, it's a little broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield.
Yeah.
These statements are relevant only to explain the reactions and responses that they elicited. That is, the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so here's my concern. For example, Ms. Murphy also testified about Judge Moreland, about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, are not, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read.
Response?
Judge, I don't really, I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, Doug, statements of Doug Benefield, this person, that person, this person, I don't know that that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped. So it was my understanding that the instruction that was requested was specific to any Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions and effect that those statements had on Miss Murphy, and telling the jury not to consider the statements by Doug Benefield as true, but only to establish the context of subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give the jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true. that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand. So I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want, respectfully, Your Honor, on behalf of Ms. Benefield, what I want the jurors to understand is that as it relates to Ms. Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Ms. Murphy.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong.
I didn't hear anything
She did
about
start to
medical
mention that
records.
she checked herself into the hospital. There was an objection and she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So everything that a defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Popo Gigio, I think we could agree that that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Ms. Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. That way, Judge White, it expands the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records, or Judge Moore.
All right, thanks both very much. At this point, I don't plan on giving any sort of cautionary or limiting instruction. I've heard parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds. There's been, I think my information in front of me is that Ms. Murphy is a fact witness. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not, or any sort of evidence is hearsay, that's a judicial matter, not a legal. It's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is already factored into a court's ruling if a statement is offered, if an out-of-court statement is offered to prove the truth of the matter asserted in the statement, it is hearsay. The issue then becomes, is there a recognized exception to that statement or to that hearsay? And is it relevant and material to the case? That's how I'll continue to make my decisions, subject to the objections and the arguments that are made. Are we ready to bring the jury back in?
One scheduling question, if it's okay with Your
Mhm.
Honor. We have, after Ms. Murphy, we have 2 law enforcement officers here, and then our next witnesses are Dr. Broder and Dr. Quintal. Do you feel like I'm safe in telling them they could come after lunch? That was when they originally scheduled, but they have patients, they're asking if they need to cancel to come early.
I have no idea how long these next, I don't know how long Ms. Murphy's going to take. I don't know how long the next 2 witnesses are going to take.
Well,
I have no idea.
I guess the question is, Judge, if we end at 11:30 or 11:40, are you going to want to take a lunch, or do I need to have Dr. Broder here? Because he's in with patients right now, so I need to be able to tell him. We originally thought he was after lunch.
You mean with Ms. Murphy?
We have Ms. Murphy and then 2 other witnesses we plan to do before lunch. I just want to know if I'm safe to tell the doctors they can come after lunch so they don't cancel patients.
My habit would be if we finish with witnesses around 11:45, unless that very next witness was both sides agreed it's going to be just 5 minutes, I would probably take a lunch break at that point.
Thank you. I asked it for that. That's my question. I just want to be safe in releasing them so that, Your Honor, so we can keep moving. Or not releasing them, putting them after lunch. 1:30? Should I tell them 1:30?
It depends on when we finish this morning. I
I'll
don't
just
know.
tell them it's after lunch for now. Thank you, Judge.
You ready to bring the jury back in?
Yes.
Vince? All right, let's bring Ms. Murphy in first.
Yeah, I agree with you, but I don't know how else they can get this in because it's hearsay. It's court proceeding stuff. So how else?
So again, did you discuss your
How
testimony?
else
Anyone
do they
else?
validate it unless they validate it through the attorney that was involved?
All right, man, while you were outside, I did sustain 2
I don't know any
objections
other
that were
way to
raised
get
by
it
the
in.
defense, and that is some of your
But
testimony.
They're
has
not
been
getting much
editorial rather than
because it's
factual,
hearsay.
and has been
So,
characterizations of observations as opposed to observations.
Okay.
So just FYI, I
but
did
I
sustain
would
those
like
2
to know.
Okay.
Otherwise, we're just going to keep having questions and
I
answers.
mean, it's
We don't
interesting
object
that
to
they
this.
had this period of
Put the jury in.
before things got bad again. You know what I mean? So I would love to know. I wish he quit objecting. I would love to know all this stuff. It feels very relevant to me.
All right, you all can have a seat. Welcome back, everybody. Did anybody begin discussions amongst yourselves? Talk with anybody outside the jury about the case, or do any research on the people, places, things, or legal topics we've heard anything about? Everybody says no. You may resume your question.
And I believe as we left off, Ashley and Doug were not speaking to each other. Pretty much not speaking to each other.
Right, beginning on August 16th, 2019.
Yeah,
were
they
not
should
speaking
find
together.
some way to
And
get
as a
it all
result
in
of that, did you ultimately file
because
anything
it's
on Doug's behalf?
important.
I ultimately did, yes.
Okay, and what was that?
We filed I think back, it was so many years ago now, a series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the pairing plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I learned that there was a series of complaints filed with.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Relevance.
So of course we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Editorialized. Sustained. That would ask for a yes or a no.
Okay.
Can you repeat the question for me?
Those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective Team.
So an evaluation was recommended.
I sustained it.
I requested instruction from the board to disregard the last answer.
Members of the jury, I have sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you of one of those very important instructions. If an objection is made, you're not to guess or speculate as to why it was made. Likewise, you are not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard that last answer.
As part of this process, with
Sufficient?
I'm sorry.
Thank you. Yes, sir. Go ahead.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection. basis?
Editorializing, not responsive to the question.
Oh,
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur, I believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and what is that? How does that play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's generally a certified family court mediator. And so what it generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation.
Correct.
Okay. And did you participate in the mediation?
I did. Of course.
And also Doug and Ashley Benefield.
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Objection. Not responsive, editorializing.
I'll sustain on the narrative.
So they did a joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties.
Oh, of course.
Objection relevance. It's what's taking place in this case.
Ooh,
A judge would not just release, is not able to. Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless.
The judge orders that it can be released.
And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to
Object
Maryland.
speculation as to what path forward was.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling. And then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report.
Okay.
And they were going to pursue the move to Maryland.
So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological evaluation.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday. So the mediation was a Thursday prior to the killing. And then the hearing was supposed to be Wednesday, the 30th,
Okay. And what day was Doug killed?
Sunday night.
And that would be the 27th?
Yes.
And who was the judge going to be at this hearing on the 30th?
Oh, it was still Diane Moreland. She was still the judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter of fact. It was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
Thank you.
Cross.
Yes. Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
So your specialty is family court,
Family law, yes.
and you've been practicing family law, I think you've told us 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are rules and procedure that apply to family court, are there not?
In all courts, including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional Conduct?
Relevant stuff?
I'll overrule. I don't know where this is going, so I'll overrule for a moment.
Thank you.
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that she
May I
just.
approach the witness?
Yes.
See if this refreshes your recollection as to the date.
I need to get my reading glasses, Mr. J.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes.
Yes.
The contents, no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5? Ms. Benefield makes some allegations there, does she not?
She does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I approach?
Yes.
Let's see if this refreshes your recollection.
Thank you.
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and
Okay.
filed on his behalf.
That
Yes.
you drafted and filed on his
Yes,
behalf.
correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevance, Judge?
I think,
I'll overrule on those
yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long. So I was just checking to see if that was correct.
Well,
Yes,
your answer.
we denied these allegations
Okay.
that he committed those acts during pregnancy.
now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition, while,
Sustained.
Your Honor, she opened the door. She's already talked about,
Would you like to approach?
yes.
Darn it, we're all cut up. Yeah, a timeline of what happened when, as far as all the court documents that have been filed. That would be nice, but like my notes on this part are, they don't make sense because of all the objections. I don't know what's what because he keeps objecting. The biggest thing I've gotten from this is that he had to hire a lawyer to draft a letter to ask to be there when his child was born. And they had to have a hearing in front of a judge for him to get visitation rights. And then when he meets his daughter, he jumps in the car to go with them. And then they reconcile. This case is crazy. I was going to try to do recaps. And then I was like, no. Because I'm not able, I don't have the legal brain to put it in a nice, tight, little nice package like Alita does. So I'm just waiting for Alita's recap so I can figure out what I missed. Because I'm sure I'm missing something. And it doesn't help that he talks so slow. Because I feel myself kind of just sometimes, you guys can probably see it on my face too. There are times when I'm just like, okay, he's talking again. Oh wait, I gotta pay attention. I'm doing the live streaming this time. I have to pay attention. I don't have the luxury of just, I'm bored. But I do enjoy this prosecution because they're just get in and get out. It's not 1,000 stupid little questions like Lally. Was it snowing? Who, if anyone, was driving the ambulance? What did you have to drink? Yeah, it does. I wanted to start on time because I didn't know if anybody was going to show up. Well, yeah, and I can't explain law. But I appreciate you guys being here. But there's, and my husband was like, yeah, but they're lawyers. Why are you doing this? And I said, there's lots of people that aren't lawyers that do this. And I said, because Elite is not doing it, I wanted to have a place where we could all be together and watch it instead of like being all spread out to other lawyers. And I said, gotta start somewhere. I mean, I did already have my own channel with my true crime videos. And I'm trying to do other things, like not, because before I was kind of just doing like Criminal Mind type, like looking at the TV show and doing cases related to the TV show. Absolutely. Like I said, I didn't even know anything about this case. Like I didn't even know what the charge was till a few minutes ago when I Googled. It's second degree murder. Yeah, and then after yesterday when I got done live streaming, a whole bunch of people were still live. And I was like, those are people that know stuff and have viewers that are asking them questions. Well, thank you, because I feel like a bump on a log right now. I really am glad that you guys are here, and I really do appreciate it. And I am doing the best that I can. I feel like I have imposter syndrome right now. I feel I'm gonna cry. I feel like I'm pretending to be a YouTuber right now. I used to make fun of my husband for watching YouTube because that's all he does. He comes home from work and he either plays video games or watches YouTube. And I used to be like, who watches YouTube? That you look up stuff like tutorials, find out how to do stuff. You don't just sit and watch YouTube. And then the Johnny Depp trial happened, and I had to watch it because I'm a huge Johnny Depp fan. And I actually believed Amber because I had heard, and I know supposedly Amber Heard started the Kate Moss rumor, but there was a rumor back in the 90s that he pushed his model girlfriend down the stairs. It may not have been Kate Moss, but there was a rumor that he pushed his model girlfriend down the stairs. So I believed her because I had heard that rumor back then. But then my stepdaughter says, no, she lied and she got her friends to lie for her. So then I was like, okay, wait, hold up. I got to watch this trial. And so I found EDB and I watched that. And then because of that, I found all the other law tubers and I got hooked. And then I was like, I wish I had something that I could do a YouTube channel. And then I thought, that's it. Because I had always wanted to check the crimes that are mentioned on Criminal Minds and like learn about the real life cases. And then I got started doing that. And I would get bored. Like if it was a case, if it was like an episode that I wasn't really interested in that type of crime, I would get bored and then I wouldn't want to do it. And then I would either take a break or something would happen. And then I got my shoulder replaced and I took like a 6-month break. And then my back started hurting and I took a break. I mean, my back is still bad, but it's not going to get better anytime soon. So I was like, you know what? Screw it. I want to do this. I'm going to do it. And I'm on the heating pad right now. I'm going to either hurt in the bed or I'm going to hurt sitting up in a chair. So the last pre-recorded video I did was about the burning of Bridget.
All right, members of the jury, here's what we're gonna do. I'm gonna go ahead and let you go to an early lunch. It's about 11:20 right now. So the good news is you get to beat the crowds wherever you decide to go. If you could be back downstairs in that jury assembly room where you start each morning at 12:30. And we'll look forward to getting you back up here as soon as we can after that. Please remember, if you do go out somewhere and have lunch, if you go in a group, that's just fine. You can absolutely go in your groups, but do not discuss the case at all amongst yourselves or anything about the case. Don't talk about the case with anybody outside of the jury. And please don't do any legal research or research on the people, places, things, or legal topics we've heard anything about. Again, if you're sitting somewhere and you just kind of hear in the din of the people behind you something about the case, just let them know, hey, I'm a juror in this case. I need you to stop. If they persist, please leave and report it immediately to the deputies. All right, we'll see you back hopefully around 12:45.
I thought it said 12:30.
All right, you're going to have a seat. The jury's out. Ms. Murphy, we're going to take an early lunch break. I want to remind you that the rule of sequestration has been invoked, so you're not to discuss your testimony or the questions asked of you with anyone, including the attorneys. You're not to discuss your testimony with any other witnesses or talk about what their testimony was or will be. You're not to view anything about this case.
Yes, sir.
All right, we'll see you back here. If you can also be back about 12:30.
Okay, no problem.
All right, we'll see you guys back here at 12:30.
Okay, I guess we will be back at 12:30. Yeah, so my latest video that I did a couple weeks ago was about the burning of Bridget Cleary. It happened in, I forgot what year, like 200 years ago in Ireland. And her husband thought that the fairies had replaced her with an imposter. And he was trying to get the fairies to bring his real wife back. And he burned her alive. And it's possible there is a mental health condition called Capgras syndrome where it can be caused by different forms of dementia. It can be caused by Alzheimer's. It can also be caused by a head injury because I'm trying to remember what part of the brain. Anyway, the emotional center of the brain, when you see someone, the emotional part of your brain gets triggered. Now, when you hear somebody, the pathway goes from your ear to that part. So it's like a different pathway. So when you get the head injury, it cuts the pathway to the emotional part. So when you see the person, you don't feel that emotion anymore. So you see the person, you recognize the person. They look like your loved one, but you will look at them and say, you aren't my mom or you aren't my dad. But because the auditory doesn't get severed because it comes in a different spot, then like they can talk to them on the phone and they recognize their voice and they recognize them for who they are. But then if they see them, then they say, oh no, you're an imposter. So it's a very weird mental disorder. And so now looking back at that case, they think that that guy might have had that. But the only thing is, her dad thought she was a fairy changeling too, and was like supporting his son-in-law to kill her. So it's a really interesting case. So that was my last video that I did. And my next one, which now because of this trial, I don't know when I'm going to do it, is it's going to be the Slender Man attempted murder. The two little 12-year-old girls that took their 11-year-old friend out into the woods and stabbed her to please the Slender Man. So that's another crazy one. So I kind of I redid my YouTube banner to kind of rebrand a little bit, because I like weird cases. And so I still love Criminal Minds, but I wasn't finding like as much interesting. I like, oh, it is very, very sad. It is a very sad story. But she was a very independent woman, and like back then women were not the breadwinners. She she designed and made clothes. She had a treadle sewing machine. It had the pedal, because back then no electricity, but it had the pedal, and she worked the pedal with her foot and it made the machine work. So she made beautiful hats and dresses, and she was a breadwinner. She had chickens, so she delivered eggs to people. And her husband was a cooper. He made barrels. And there was also like a rumor that she might have had a lover, but I don't know if that's true or not. But she was different because she was an independent, like she made the money. She didn't need to have a husband, and she didn't have kids, which was another thing that was unusual back then. So she was different. So, was she killed because she was different, or did he have this disease, or was she a fairy changeling? It's like, or was it just an excuse for him to get rid of her? But the Slender Man thing, one of the little girls, I think, has schizophrenia because her dad's a schizophrenic. But no one died in that one. The little girl, yeah. The little girl in the Slender Man one, she lived. And I think they stabbed her like 19 times. That little girl was a fighter. So, but I like the ones that are like tied in with stuff like that, like urban legends and weird medical conditions and stuff like that. I don't know. I'm weird. I'm weird. Okay, so I guess we will meet back here at 12:30 if you want to. No pressure. I talked to myself yesterday for a while, so I can do that again. Thank you guys so much for being here, though. I really appreciate it. And thank you for the positive feedback, even if you were just saying it because you're my friend. That's okay, too. Okay, guys. I'll see you later. I love you both. Bye.